criminal defense attorney, Neil Rockheim.
Hey everyone, it's Neil Rockheim. Welcome to another edition of Killer Cross-Examination. I want to get right to the subject. I want to talk about prosecutor appeals. As you're hearing that, you're thinking, what do you mean prosecutor appeals? Prosecutors can't appeal. Prosecutors, we've got double jeopardy, and if a prosecutor loses a case, that's it, right? I wish that were the case. I really, truly do. I wish that when a defendant or a client of ours or when we win a legal issue after a very hard-fought battle, we get a case dismissed at a preliminary examination. We have a judge find that there's no probable cause to believe a crime was committed. Or we have a judge who suppresses evidence and finds that the charges should be dismissed, or even a finding of entrapment, where a judge says that our client was entrapped or our client was judicially entrapped. In other words, a police officer or public official gave our client the go-ahead to do what it was that he did. And the judge said, well, you can't tell someone to go ahead and do this and then prosecute them for it. And cases get dismissed for a variety of reasons by a judge. I wish that when a judge dismissed a case, that was the end of it. I wish. Unfortunately, that's not the case. Those prosecutors have always said, we've always talked about how powerful judges are. And we've talked about on the street how powerful and how much actual power in your everyday life, from moment to moment, minute to minute, hour to hour, police officers have, because they are the tip of the sword for the law. They're the ones that have the power to arrest you or to detain you or to let you go. But truly the most powerful entity in the criminal justice system is the prosecutor. I've said it time and time again, prosecutors have the most power. They have the power to bring a case, they have the power to terminate a case. And if they don't like a ruling from a judge at a preliminary examination, which is a probable cause hearing, or they don't like a ruling by a judge in a motion to suppress evidence or a hearing to suppress evidence, or they don't like an entrapment ruling, or they don't like any ruling where evidence is excluded or charges are dismissed, the prosecutors don't like it, they can appeal. And it's maddening and frustrating and heartbreaking for our clients. It's one of the worst bits of news that we have to deliver to our clients after they felt the thrill of victory. Remember that old WA or that old ABC Wide World of Sports with they would have these different types of sports activities they would cover on a Saturday and a Sunday. One of my favorite things as a kid was watching the Wide World of Sports. And they'd have Jim McKay would be announcing the Wide World of Sports. And they would talk about the thrill of victory, and they would see someone winning and running across the line and breaking the tape, and the agony of defeat. And they would show that poor ski jumper who's jumping, and he slid off the side and onto the barrier and onto the wood. And I've had cases with clients who have experienced the thrill of victory, the relief of having a judge validate that they were illegally stopped or illegally searched. Have a judge validate that the breath test or the drug test was improperly stored or was unreliable and thus was excluded from evidence. And I've had cases where a judge has ruled that a police department's entire breath test, their breath test is inaccurate, shouldn't come in any case. And we've had judges who've ruled that our clients were the police were, and the prosecutors were judicially estopped, called entrapment by estoppel, where our clients were told they could go ahead and do something, and they were given that opinion or the appearance that it was okay to act as they did, and then they were arrested and prosecuted. And our clients feel the relief, the tension, you can see it, just the the stress of being charged with a crime, of facing prosecution, facing potential imprisonment or incarceration, then you can see just the relief takes over them. Doctors, lawyers, teachers, people with licenses, people without licenses, all variety of people have experienced that relief that we've been able to bring them, that a case has been dismissed or evidence has been excluded and the prosecution can't go on. And people's faith in the legal system is restored. Their faith that there's someone out there willing to fight for them is restored and replenished. Their belief that the legal system can work for the little guy and that the police and prosecutors don't control everything is reinforced or instilled. And then 2 or 3 weeks later, we have to deliver the awful news that a prosecutor has appealed. The prosecutor has said that the judge made a mistake and that they should go to the next highest court as an appellate court and seek to overturn that ruling, and the look on our clients' faces when that happens is devastating. It's awful. How can they do that, Neil? It doesn't seem fair, Neil. It doesn't seem right. I agree. I think in a legal system where the system is based on the idea that the accused is presumed innocent and the rule of lenity, which is that when there's any doubt about how a law or something should be interpreted, it should be interpreted in favor of the accused. The sort of tide goes to the runner, sort of analogy. That any time the judge rules in favor of the accused, that ought to be the end of it. But it's not. Prosecutors have the ability to appeal, they have the power to appeal, and they have, in some cases, the right to appeal. And because the legal system for years, the pendulum has swung for years from liberal in the 60s and 70s to conservative and police, the reinforcement of sort of I don't say the police state, but the reinforcement that the police have rights and that the victims have rights, and that the courts have swung the other way at times to more conservatively. And because the courts have swung conservatively over the years, and they go back and forth, but have swung conservatively, or there are parts of the state or the country where we see people appointed who are very much in favor of the executive branch, very much in favor of the police, very much in favor of the prosecutor. They come from areas where the idea of civil liberties and civil rights is almost offensive. When you say, like, I'm pursuing a civil rights case, they look at you as though you're just like farted in church. And because we have parts of society that have put candidates in the judiciary, whether it's state or federal, that have that sort of mentality, prosecutors have, in many places, very accommodating audiences. They've got people in the judiciary that are interested in hearing these appeals, who are interested in looking at things from the perspective of the police officer, who are interested in giving police officers the benefit of the doubt. And so a ruling that a client of ours, we worked hard for, that other lawyers worked hard for to get on behalf of a client, can be reversed. Our client can go from the thrill of victory and relief of having charges dismissed and evidence suppressed to having their case reinstated in as quick as it takes for a judge to type out an order. On a Wednesday morning or Friday morning, our client could be not charged with a crime, and by Wednesday evening or Friday evening, The judge has issued an opinion. That opinion's made its way into the court record. The court reinstates the charges against our client. The evidence that was excluded due to an unconstitutional procedure is back in. A client who was granted bond at a bail hearing is now all of a sudden detained and told to report to the jail or to a marshal's office. It's devastating. I've yet to find a great way to break the news to a client that their charges have been reinstated, that the case has been reversed. I have clients who are like, Neil, how long can this go on? And we tell them, you have to keep battling, you have to keep fighting. I wish that weren't the case. I wish that any time there's any opportunity or room for a district court judge or a circuit court judge or any judge to rule in favor of the accused, that was the end of it. Because that would tell me the system was leaning or slanting in favor of the accused at all times. If there's a single judge out there that could think that this was wrong, then that should be enough to protect that person. But it's not. Prosecutors can appeal, and those prosecutor appeals can be like arrows, like a sharp, poisonous arrow in the heart, spirit, will, and determination of a client, someone that they had girded themselves, they're ready for the battle, and then they get the word that the case has been dismissed or the evidence has been suppressed, and they let their guard down and feel elated for a minute. And then prosecutor swoops in and appeals, and they happen to get a favorable assignment to a judge. And then that judge rules against our client. And it's devastating because they were once prepared for the battle, but our client has lowered their shield, so to speak. They've taken a deep breath. They've exposed themselves back to the real life. They've allowed themselves to think that this battle might be over. And then they're wounded a second time, this time even worse because they had it and now they lost it. And one of the problems is that there were prosecutors and prosecutors' offices that would appeal everything. Some didn't even they don't have to appeal. They could choose not to. They could choose to exercise their discretion and not appeal, not force a case. But there are some prosecutors who have the mentality that they have to or that they're going to. They're just not going to take the loss. They're not going to accept it. They're going to push on. It's fucking maddening. Because they don't have to do that. They just choose to. They choose to appeal everything. And when they choose to, so the prosecutors that do that, it's almost, that appeal everything, it just has a way of just casting such a dark cloud over the entire legal system. You work so hard. You put your faith in the trial court judge who watches the witnesses testify, makes a call that the witnesses aren't truthful or aren't believable. And then you get a prosecutor who isn't even thinking about, like, you know what, maybe I just put on a bad case or my witnesses sucked or I was just wrong. They're thinking, we got to appeal. We got to appeal. We got to appeal. You got to appeal? Appeal? You got to appeal? Then we got to appeal. We have to appeal. We need to appeal. We got to fight this. We can't take this. We got to appeal. And it's no sweat off their back. If the prosecutor loses the appeal, so they lost the case. The prosecutor wins the appeal, they're back in action, back on the field. But for the accused, for the citizen, for our client, it's everything. Prosecutor appeals, they win the case and they're elated. They're not going to jail. They're not facing a criminal charge. The prosecutor appeals, to them, que sera, sera. To our client, it's life and death. It's maddening. I talk about that because I've yet to figure out a way to, other than just to deliver the news to the client, try to keep them moving forward, one foot in front of the other, how to explain the prosecutor's appeal. We're currently battling a few cases on appeal with clients right now where prosecutors have refused to take the L. They've lost. We pitched a near perfect game. Judge ruled in our favor or counted the prosecutor out. 1, 2, 3. UFC type or count to 10 in a boxing match. They hit the 10, and instead of just taking the L and say, you know what, I'll move on. The prosecutors want to appeal. The referee wasn't the right referee. The referee didn't do a good job. It wasn't really a 10 count. It wasn't really a knockout. Whatever. They want to appeal. To our client, if they lose, they have to fight again. It's one of the things about the legal system that is the most frustrating. I'm going through that right now in several cases for clients of ours. And I hate it. I hate it for them. And because we're going through that, I thought this was a perfect opportunity to express our frustration. If you're someone who's won a case and the prosecutors appeal, all I can tell you to do, all I can hope that you do is just dig in, talk to your lawyer. Make sure your lawyer gives you the straight shot about what the appeal looks like, what the process looks like. Keep your guard up. Make sure your lawyer is keeping you informed about what that appeal process is like. And good luck. Prosecutor appeals are frustrating because prosecutors have so much power and they have almost no consequence if they lose the appeal. But it's another alligator that we have to wrestle, and wrestle we do and will. But I thought it was a good time to talk about it because I've seen the look on our clients' faces when they have to go through it. And I hate it. I hate it for them. This is Neil Rockine talking about prosecutor appeals, one of the worst bits of news that we have to deliver to a client when a prosecutor actually appeals an adverse ruling. This is Killer Cross-Examination. Thanks for tuning in.